We know an executed contract can refer to a contract under which both parties have fully performed their obligations, and there can be executed written and oral contracts. But what happens if the validity of an executed oral agreement is challenged and one of the parties is dead? The 1949 case of Estate of Raphael examines this question in the context of an inheritance dispute. Bertha and Raymond Raphael were married in August of 1939. 9 months later, Raymond inherited some property from his mother. According to Bertha, she and Raymond regularly discussed that they were equal partners. He told her that what's his is hers, and vice versa. She also said that Raymond would often say that everything they had with each other, and that everything was 50-50. Bertha's tax returns from 1941 to 1944 reflected this as well, because she consistently reported half the marital income of both Raymond and herself. Bertha also remembered Raymond saying, around the time they filed their 1941 return, that she has half and he has half, referring to their marital assets. In 1946, Raymond died. Raymond's brother, Henry, was appointed administrator of Raymond's estate. As administrator and brother, Henry filed a petition in trial court for an equal split of Raymond's estate between himself, as heir at law, and Bertha. In support, Henry contended that Raymond's estate was Raymond's own separate property, and that as such, he and Bertha were each entitled to half. Bertha contended that all Raymond's property was transmuted to community property and provided supporting testimony and tax returns. The court determined that Raymond had indeed transmuted all his separate property to community property, and that his entire estate, therefore, was the community property of both him and Bertha. Henry appealed, claiming the trial court's determination wasn't supported by the evidence.